Hello, I'm attorney Bob Bergman, and welcome to my Living Trust seminar, Inheritance Planning for You and Your Family in 2014 and Beyond. It is my hope that the information presented in this seminar will help you to be better informed about estate planning and the planning options that you have available for you and your family. It's very important that you do not try to take any of the information that I present in this seminar and try to apply it on your own. Estate planning is a specialty in law practice, and there are many mistakes that can be made without the guidance of an experienced counselor. A little bit about myself. I've been a resident of Santa Clara County since 1968. I went to local colleges in that county, including De Anza Junior College and San Jose State University, and I have my Juris Doctor degree from Santa Clara Law School. I'm a board-certified specialist in estate planning, trust, and probate law, certified by the State Bar of California Board of Legal Specialization. As a specialist, I'm uniquely qualified to assist families with their estate planning needs. I'm also a member of Wealth Council, a national association of over 3,300 estate planning attorneys and other estate planning professionals. Working with proprietary drafting software, Wealth Council members share planning ideas and techniques, and assist each other in order to provide the best possible estate planning services for their clients. I've also served as general counsel for a residential real estate company in the Silicon Valley, and as a real estate broker, securities broker, financial planner for MetLife, and vice president and business development officer for Comerica Bank Institutional Trust. In this presentation today, I will be describing just what estate planning is and some of the reasons to do estate planning, and the advantages and disadvantages of the various planning options that people use. These include doing nothing at all, making a will, using joint tenancy ownership of property, using beneficiary designations, and using the Revocable Living Trust. By the end of the presentation, it is my desire that you are better informed on the advantages and disadvantages of the various planning options available. In order to discuss estate planning, we need to first define what is your estate. Your estate consists of those things that you own. These include retirement plans, your residence, perhaps residential or commercial income properties, cash in the bank, stocks, bonds, and mutual funds, automobiles, and antiques. It also includes life insurance policies, which are an asset that is often missed because it does not pay out until somebody has died. Your estate also includes your spouse or partner, children, parents, or others you consider to be your family. This means that your estate actually includes the things that you own and your family as well. Here's a good working definition of just what estate planning is. I want to control my property while I'm alive, take care of me and my loved ones if I become disabled, and give what I have to whom I want, the way I want, and when I want. Furthermore, if I can, I want to save every last tax dollar, professional fee, and court cost legally possible. I find that most of my clients have this in mind when they come to see me, and this is what they mean by estate planning. There are lots of reasons to do estate planning. For example, a family may be concerned about the family fighting over an inheritance, so they want to make sure that everything is in writing so that their wishes concerning the distribution and use of the estate are clear. Other families are facing an emergency situation where a loved one has been diagnosed with a terminal illness or other medical condition. Such planning is stressful for the family and the attorney as well, but much can still be accomplished in a short time as long as the loved one is still mentally competent to do the planning. Those parents who have young children may need to nominate guardians for them in case something happens to the parents. This is especially a concern if potential guardians do not live within the area or maybe even live outside of the United States, as is the case with many of my clients. Without proper planning, minor children could end up in the foster care system for days, weeks, or even months before a guardian could be appointed by the court. Many families have a special needs child or other relative. Without proper planning, the inheritance of the special needs person may be lost to the government or required to be completely spent before the government is available to assist the person. Some families are concerned about an extended nursing home stay causing the loss of family wealth due to its expense. They want to plan for that possibility, or at least provide a way to plan for it in the future. For other families, taxes and bills owing when a family member dies may result in the loss of the family home or business because there is not sufficient cash available in the estate to pay those taxes and bills. Most families will look at the following reasons to actually do estate planning. They want to avoid conservatorship while they are alive and probate after death, eliminate or at least minimize legal fees and estate taxes, and preserve their estate for their families. Sometimes they want to pass on their values to their family and above all have peace of mind, knowing that there's a written plan in place for the family to follow. Families come from many different backgrounds with different ethnicities, religions, cultures, and financial situations. Because of this, one-size-fits-all planning is not appropriate for a family because every family's situation is different. If you're married or unmarried, have children or no children at all, many of the issues are the same. Throughout this presentation, if something applies only to those who have children or only those who are married, it will be very clear. For those who have minor children, which is defined as children under the age of 18 years here in California, there's an important question that needs to be answered, a question that every parent has asked themselves at least once. If I go out tonight and don't come home, what would happen to my children? The reality is that without proper planning, your children could end up in the broken, underfunded foster care system for a few hours, days, or even weeks. They could end up with relatives you would want to raise them, or maybe with relatives you would not want to raise them. Or, with proper planning, they could end up with close family friends instead of your own family if that is your wish. To deal with this issue, I have developed the Children's Legacy Plan. This is a series of legal documents designed to deal with the short-term and long-term needs of our minor children. There are documents to name temporary caretakers that we've authorized to care for our children until the court can appoint a permanent guardian. There's a medical power of attorney for our children, and even a document to exclude those family members we may consider to be bad choices as guardians, the confidential exclusion of guardians. For anyone who has property to leave as an inheritance, this is another question that needs to be answered. Will the assets I'll be leaving to my spouse, partner, children, or other heirs be protected from a long, complex, and expensive court process? To help with our discussion on estate planning today, I'd like to introduce Mary and Ed Ramirez. Mary and Ed have two children, their daughter Karen, a recent graduate of San Jose State University, and their son Paul, an engineer at a tech company in Palo Alto. Mary and Ed wanted to know what their estate planning options were. Well, first of all, let's talk about the most popular planning option in the country today. In fact, about 2/3 of Americans choose this as their estate planning option of choice. What do you think it might be? Right, doing nothing at all. In fact, about 2/3 of the country have this as their estate planning choice. Now, there's some advantages to doing nothing at all. There's no out-of-pocket costs. You don't have to deal with lawyers or paperwork. You don't have to think about dying. And for some people, their attitude is, hey, I'll be gone, so why worry about it? The decision to do nothing is called dying intestate. This means that you have no last will and testament, and the state of California has written a plan for you. It's called the Laws of Intestate Succession, which is a fancy legal way of saying who gets your property when you die if you don't have a plan. When you die as a resident of California, if you have property in your name or payable to your estate that is greater than $150,000 in value, or if you have real estate worth more than $50,000 fair market value, your estate will go to the probate court in your county of residence, where the probate judge will decide who gets your property based on the laws of intestate succession. The probate process follows a timeline which is illustrated here. Paperwork has to be filed, notice has to be given to your heirs and creditors, and finally a court hearing is held where the court appoints a personal representative to handle your estate. In Santa Clara County, where I practice law, the time lapse between point 1 and point 3 is about 60 to 80 days to have a probate court hearing where the probate judge actually appoints someone and grants authority to act. The paperwork may also be filed with the probate clerk after the court date is scheduled. Many counties in California do not even schedule a court date until all of the paperwork is actually filed with the probate clerk. Many fees and costs associated with the probate process are paid to various parties, including the attorney, the probate referee or court appraiser, and the personal representative. These costs can be a significant percentage of the value of the estate. We sometimes say the probate judge brokers the inheritance to the heirs. Fees and costs are based on the market value of assets, not the net value. This $1 million estate could be a home that has a $1 million loan on it. It's still a $1 million probate estate. Additionally, everything becomes public record in the probate process. Everything you own, everybody you owe, who your heirs are, including their names, ages, the property they're receiving from your estate, and where they live. Additionally, because of the public nature of the probate process, there are charming people like this who go through the probate records looking for their next victims. Many people have had inheritances lost to con men such as these. They've been convinced to make phony investments or purchases, or the con men find other ways to separate them from their inheritance. Con men have been working the probate files long before the families of dead Nigerian ministers or faked deceased relatives' fortunes on the internet. Because of budget cuts, probate typically takes 1 to 2 years or more here in California. It is not unusual for probate to take longer than that if there are problems with the estate. A minimum of 1 year seems to be the norm throughout California, with many courts taking far longer. Because it takes 1 to 2 years or more before distribution of property to your heirs, and because the probate court actually puts a limit on how much property can be released ahead of time, it may well be that there is no money available for tuition for children's school, or money to buy a home or start a business. This is because the property is all being tied up in the probate court until the judge orders it distributed at the very end of the process. Additionally, if you happen to own real estate in states other than California, it's possible there will need to be additional or ancillary probates in those other states. It's not unusual for a family to walk away from something like a deeded timeshare in Hawaii or Florida because the cost of probate may actually exceed the value of the timeshare itself. Because of all the drawbacks of doing nothing at all, doing nothing is probably not a good planning option. A more common planning option is to make a will or last will and testament. Contrary to some popular belief, a will does not avoid the probate process. In fact, having a will means that you want your estate to go through the probate process. This is called dying testate, which means that you have a last will and testament. Similar to dying intestate with no plan, when you die as a resident of California, if you have property in your name or payable to your estate that is greater than $150,000 in value, or if you have real estate worth more than $50,000 fair market value, your estate will go to the probate court of the state of California. The probate judge will follow your wishes as expressed in your last will and testament. A will does not affect certain types of property that you may own, such as beneficiary assets or joint tenancy assets, both of which are discussed later on in this presentation. But there's another problem. You see, Ed suffered a stroke, ended up unable to handle his financial affairs. His wife Mary went to Ed's bank to try to get some money out of Ed's IRA to pay some medical bills. But the bank officer told Mary that she had no authority to get money out of Ed's IRA. This was in spite of the fact that Mary had a will, naming her as Ed's personal representative. You see, because Ed is still alive, his will has no effect. In fact, it is not effective until he has died. Because of this, Mary will have to go to the probate court to get a conservatorship for Ed. A conservatorship is a guardianship for an adult. It's sometimes called a living probate because many of the steps that take place in the probate process also take place when somebody goes through the conservatorship process. The probate court will appoint Mary as Ed's conservator to take care of Ed as the conservatee. Ed is said to be conserved. Conservatorship has its own set of fees and costs associated with it, including court investigators' fees, attorneys' fees, and ongoing accounting fees for as long as a person is conserved. You can avoid conservatorship by having other legal documents in place besides just having a will. First of all, the general durable power of attorney. This grants authority in advance to someone to handle your financial affairs. There's a form that the state of California has created called the Statutory Form Power of Attorney. Unfortunately, the statutory form is inadequate because there are many types of powers and authority that you might want to grant to someone that are not actually contained in the form itself. Unless you have access to a copy of the probate code and know what you're looking for, you will not realize what those powers are that are missing. Some of those special powers include the following: authority to make gifts, authority to do more estate planning, and authority to do long-term care planning. The next document is the Advanced Healthcare Directive, which grants power and authority to someone that you've named as your healthcare agent to make medical and healthcare decisions for you. Again, the legislature has created a document called the Statutory Form Advanced Directive, which is available at the business office of little or no guidance to your doctors. You see, the reason for the Advanced Directive is not only to give somebody authority to speak for you, but also to give directions to your doctors if you run out of healthcare agents. The last document is the HIPAA Authorization Form. HIPAA, or the Health Insurance Portability and Accountability Act, is a federal law dealing with medical privacy. You may not realize it, but even if you are married, your spouse cannot legally get any medical information about you from your doctor or any other healthcare provider without your express written consent. The HIPAA authorization tells the healthcare providers to whom they are actually authorized to release medical information. If you have less than $150,000 in your estate when you die, with the total value of real property being less than $50,000, it may be sufficient for you to use a will combined with the General Durable Power of Attorney, Advanced Healthcare Directive, and HIPAA authorization form. However, if you own a home or have more than the $150,000 limit, this will not be a sufficient planning option for you. There's a popular... The major feature of joint tenancy is the right of survivorship. This means that whoever is the surviving joint tenant will receive the interest of the other joint tenant who died by operation of the law, without any probate process being necessary for the joint tenancy property. Joint tenancy property is part of your death tax estate, which means that it's subject to federal estate tax, discussed later in this presentation. Joint tenancy property is not subject to probate proceedings and is not controlled by any will or trust you may have prepared. Now this can cause some very important problems as illustrated here. You see, Mary and Ed owned their home as joint tenants. They were advised to do so by their real estate agent when they bought the house 20 years ago. He told them that they could avoid probate by owning their house in this way. Ed then died. Now, Mary owns the house by operation of the joint tenancy law. She did not have to go through the probate process. Instead, she filed some simple paperwork. When Mary dies, however, her house will end up going through the probate process. What happened? The joint tenancy ownership was supposed to avoid the probate process entirely. That's what the real estate agent told Mary and Ed all those years ago. The problem is that Mary, without any additional planning, owned sufficient property to force her estate to go through the probate process when she died. This means that the joint tenancy ownership that she had with Ed did not avoid the probate process, it only delayed it until her death. This is the hidden trap of joint tenancy. There will be other consequences for Mary if she decides to sell her house after Ed dies. You see, California is what is called a community property state. Married couples in California can own their property in various ways, the most common being joint tenancy and community property. In California, property owned by a married community property, on the other hand, means that each spouse owns an undivided one-half interest in the property. While this does not sound like there's much difference between the two forms of ownership, there are major income tax implications for whomever is the surviving spouse in the marriage. There's a type of property that can be owned that is called a capital asset. Capital assets include things such as your personal residence, stocks, bonds, mutual funds, investment properties, precious metals, gems and jewelry, and coin or stamp collections. Capital assets receive special tax treatment when they are bought or sold and a profit or loss is realized from the sale. These are called capital gains or capital losses. For example, let's consider a stock portfolio purchased by Mary and Ed many years ago for a purchase price of $100,000. This purchase price is referred to as the cost basis for the stock. Today, the stock portfolio is worth $700,000. If Mary and Ed sell the stock today, they would have a capital gain of $600,000. This capital gain of $600,000 would be subject to capital gains tax at a combined California state and federal rate of approximately 23%, although it can be over 38% for high wage earners. The capital gains tax rates are normally lower than the ordinary income tax rates, which are the tax rates paid on wages, salary, commissions, dividends, and interest earned. Let's see what happens to the potential income tax liability when Ed dies. If Mary and Ed own the stock as joint tenants, the tax law provides that Mary would receive a new cost basis in the stock consisting of the original $100,000 plus Ed's divided one-half interest in the equity that is built up over the years. This means that an additional $300,000 would be added to the original cost basis of $100,000 to give a new cost basis of $400,000 for Mary. This increase is called a step up in the cost basis. If Mary then sells the stock portfolio for $700,000, she would owe capital gains tax on her divided one-half interest of $300,000 of the equity. On the other hand, if Mary and Ed own the stock as community property, there's a completely different result. Because under the tax law, community property is treated as an undivided one-half interest in the property, it has different tax treatment as well. Under the tax law, there is no way to determine which half of the property was owned by Ed when he died. Therefore, the tax law assumes that Ed owned both halves of the property at the same time when he died. This means that Mary will not only receive the original cost basis of $100,000, but she will also receive a step up in the cost basis of both halves of the equity in the stock portfolio. This means that her new cost basis will be $700,000, or the fair market value of the stock portfolio on the date of Ed's death. When Mary goes and sells the stock for $700,000, her taxable capital gain is zero. A quick comparison shows that for married couples in the community property state of California, community property ownership is twice as valuable to a surviving spouse as joint tenancy ownership. It should be noted that under the Windsor decision from the Supreme Court in 2013 concerning DOMA, the Defense of Marriage Act, the capital gains income tax benefit I've just outlined is now available under federal income tax law to married gay and lesbian couples here in California. However, it's not currently available to registered domestic partners. Under California law, the capital gains income tax benefit would apply also to married gay and lesbian couples and registered domestic partners. There are some other problems with joint tenancy ownership. You see, after Ed died, Mary decided to add Karen's and Paul's names to her property as joint tenants with her, her house title, her bank accounts, her broker accounts, and everything else she owned. Mary reasoned that if she was not required to go through the probate process, then her children would not be required to go through the probate process either. Unfortunately, there were a number of bad assumptions and potential problems with Mary's approach. First of all, for Mary's plan to work, she would have to die before Karen and Paul. Most people assume that they'll die before their children, but experience suggests otherwise. In my family, for example, I have lost 4 first cousins who died before both of their parents. Next, Mary did not realize that her son Paul's tax problems with the IRS could lead to her home being sold for his share of the property, or that her bank accounts could be levied against as well. Mary also did not realize that if she wanted to refinance her home or obtain a home equity line of credit, she would have to have her children's permission and signatures because they were on the title with her as owners. She also found in her retirement years that she could not qualify for a reverse mortgage on her home to pull out money from her equity for living expenses because her 2 children were on the title of her home and the lender would not grant the loan for that reason. Mary also faced another problem when her daughter Karen and her children moved back in with Mary after Karen lost her job and her own home. The stay was supposed to be temporary, but 6 months later, when Mary wanted Karen to move out and Karen refused, Mary could not even evict Karen from her own home because Karen was on the title as an ownership. Ownership carries the legal right to possession of property, so Mary was stuck. Also, by putting her children on the title as joint tenants, Mary may have made a gift of her cost basis in the property to her children. If the property goes up in value over the years before Mary dies, her children may end up paying capital gains tax on their shares in the property when it's sold, because only Mary's 1/3 interest will receive the step-up in cost basis at her death. Because of all these problems, joint tenancy ownership is not recommended as a planning option. Another self-help planning option is the use of beneficiary designations on various types of assets. These include properties such as 401k plans, IRAs, pay on death or transfer on death accounts, annuities, and similar property. Beneficiary designations have their own set of problems. For example, when you use a beneficiary designation, you're giving up control over the distribution and use of the property in the future. Most people would think it's a bad idea to leave a large sum of money outright to an 18-year-old, but that can easily happen if the only planning used is a beneficiary designation that includes your minor children. Life insurance can end up being paid to an ex-spouse after a divorce if you don't take the step of removing the divorced spouse as the beneficiary of the insurance. This is because California's divorce laws do not remove that spouse's name from life insurance contracts. Attempts to disinherit a child or other heir by naming other beneficiaries may backfire if those other beneficiaries die before you do. In such a case, you may find that your property gets paid to your probate estate and that the disinherited heir is, in fact, your intestate heir and receives the property. The fact is that the use of beneficiary designations can easily end up with your property being forced to go through the probate process anyway. Beneficiary designations as a planning option are not recommended because too many things have to go right for them to work at all. The most flexible planning option is to use the Revocable Living Trust. The Revocable Living Trust avoids all of the problems that I've outlined that can or will occur using the other planning options. The Revocable Living Trust consists of 3 parts. It's revocable, which means you can change your mind. Whatever decisions you make today can be modified, amended, or completely changed in the future. It's living, which means that it's created while you're alive instead of after your death. A trust created after death is called a testamentary trust. Third, it's a trust, which indicates property being held by one person for the benefit of another person. I like to describe a revocable living trust as being like a wooden toy box for your toys. The toy box has three sets of people involved with it. The first are the trustors, who are the original owners of the toys or property in the toy box. In the case of Mary and Ed, they build their toy box as the trustors. The second set are the trustees, who are the persons or companies put in charge of the toys in the toy box. Mary and Ed create an instruction manual for their toy box called the Trust Agreement, and then they sign the trust agreement as the trustors and as the trustees. Ed and Mary then transfer the ownership of most, but not all of their toys to themselves as trustees of their living trust. They would not transfer their retirement plans, which are already held in a trust for them, or assets such as stock options or restricted stock units, which likely have a restriction on transfer or an assignment. The third set are the beneficiaries, who are the persons being taken care of by the trustees using the toys in the toy box and who get the use and benefit of the toys. The trust agreement tells Ed and Mary as trustees how to use the toys to take care of themselves as beneficiaries of the trust. There may also be instructions to take care of Ed and Mary's children or other beneficiaries as well. The death tax, or the federal estate tax, is a transfer tax on the transfer of wealth, typically from one generation to the next generation. One of the most important benefits of a valid marriage is a deferral of any federal estate tax liability when a spouse dies. There is an unlimited marital deduction for both direct transfers to a surviving U.S. citizen spouse or transfers in a form of trust called a Qualified Terminable Interest Property Trust or QTIP trust. The unlimited marital deduction also applies for surviving non-citizen spouses who receive property in a special form of trust called a Qualified Domestic Trust or QDOT. Both work to defer any possible federal estate tax until the death of the surviving spouse. For direct non-trust transfers to a non-citizen spouse, children, or other heirs, or transfers to certain trusts for the benefit of those people, there is an exclusion from taxation of a certain dollar amount called the Applicable Exclusion Amount, or AEA. The AEA has varied from year to year, and the value of any property transferred that is greater than the AEA is subject to the federal estate tax. This chart illustrates the applicable exclusion amounts from 2009 through today, 2014. As can be seen, the applicable exclusion amount has been increasing dramatically over the past 5 years, rising to $5.34 million today per person dying, indexing for inflation in future years, with a 40% tax on estates over that size. It should be obvious that most families will not be affected by the federal estate tax because most family wealth is well under the $5.34 million exclusion that would be available to an individual or to each spouse in a marriage. A well-drafted revocable living trust can also provide for a trust protector for oversight to assure that your wishes and desires may be carried out in the future after you're gone, especially if there are changes in the law or family circumstances. A trust protector is an independent third party who is not a trustee or a beneficiary of your trust. Attorneys, CPAs, and close family friends can be good choices for trust protectors. Trust protectors may be granted authority to make certain changes to your trust, such as replacing trustees or appointing successor trustees, making amendments to the trust to conform with changes in the law or changes in family circumstances, and moving the trust to a different tax jurisdiction for lower taxes and perhaps better trust laws or asset protection. A trust protector may also be given authority to direct the investments your trustee makes, add or remove beneficiaries or classes of beneficiaries, grant or remove various powers, modify distribution rights, and many other possible choices. A well-drafted revocable living trust can provide for asset protection for a surviving spouse, partner, children, or other heirs. This can be done by leaving the inheritance in a special asset-protected trust for the benefit of the person instead of leaving the inheritance directly. The problem is that leaving property outright to a spouse, partner, children, or other heirs may result in that inheritance being lost. For example, beneficiaries that are too young or financially immature can easily lose an inheritance through their poor spending habits and the lack of knowledge of proper investments. Beneficiaries who suffer from drug, alcohol, gambling, or other abuse problems may use an inheritance to further their addictive behavior, and in extreme cases, it can lead to serious disability or even death. A disabled or special needs beneficiary may find that the benefits that they're receiving from the government for their disability may be cut off or lost entirely if an inheritance is received outright. This is because most government programs are needs-based, and the receipt of an inheritance may trigger reimbursements for benefits already received and the loss of future benefits until the inheritance has been almost completely spent. A beneficiary who has already received an inheritance outright may unintentionally lose that inheritance in a divorce without proper planning, or the inheritance may end up passing to the beneficiary's surviving spouse and his or her family instead of back to the original family that the inheritance came from. Finally, the beneficiary receiving an inheritance who has creditor problems, owes taxes, or is in bankruptcy may find that their inheritance is taken from them to satisfy the bills and taxes. Is there an alternative to lost inheritances? Yes. It's what I call the Castle Trust planning option, more generally known as the Legacy Trust or the Dynasty Trust. The Castle Trust planning option involves leaving property in a trust for the benefit of a surviving spouse, partner, children, or other beneficiaries instead of leaving it to them outright. The trust that's created is a lifetime trust in that the inheritance inside is distributed to or for the benefit of the beneficiary of the trust for that beneficiary's lifetime needs. Distributions are generally limited to distributions for the beneficiary's needs in the areas of health, education, maintenance, and support, often abbreviated as HEMS. Maintenance and support includes things such as food, clothing, shelter, recreation, and vacation. Castle Trust planning provides all of the use and benefit of an inheritance without the problems of an inheritance that can be created by direct ownership. For example, because the inheritance is inside a trust for the benefit of the beneficiary, the inheritance enjoys a large degree of asset protection from claims made against the beneficiary. These claims could include creditors' claims, claims by a divorcing spouse in a divorce, reimbursement claims by the government for benefits paid to a beneficiary who is on welfare or has special needs, loss of future government benefits for a special needs beneficiary, or loss of the inheritance of the beneficiary is in bankruptcy. Castle Trust planning can also be used to make sure that the beneficiary is never in control of his or her own inheritance. This is especially important if the beneficiary has a drug, alcohol, gambling, or other abuse problem, is financially immature or unstable, is in a physically or financially abusive marriage, is part of a cult that demands surrender of all earthly possessions, and many other situations. If the Castle Trust planning option is used properly, the beneficiary's inheritance may also be passed on to the beneficiary's own heirs, free from the federal estate tax or the death tax, and free from a different federal tax called the Generation Skipping Transfer Tax. The Generation Skipping Transfer Tax applies to certain wealth transfers from, for example, a grandparent to a grandchild. It's also possible to grant a beneficiary a special power called a limited power of appointment. The limited power of appointment allows a beneficiary to direct who will ultimately receive the trust property, even though the beneficiary does not actually own the trust property. This can be used to change the distribution plan to both reward and punish later beneficiaries, or to plan for changed circumstances such as a new special needs person in the family. There are many self-help planning options available for those who do not wish to use the services of an attorney. These include online websites and books that can be picked up in a bookstore. The self-help planning options share a lot in common. They tend to be one-size-fits-all with little or no customization. They're often very inexpensive, but they have little substance to them, missing important provisions and not dealing with issues that may be very, very important. Finally, and most disturbing, none of these self-help options take any legal responsibility if the living trust planning does not work for your family. Unfortunately, that will usually only be found out after you've died, leaving your family in the position of having to go to court to try to fix the problems. In some cases, the problems cannot be fixed, and the result is a distribution plan that may be something completely different from what was intended. Another planning option is to use an attorney that does wills and trusts. Any attorney can represent themselves as an estate planning attorney. Passing the bar examination is the only legal qualification. Unfortunately, many general practice attorneys sell wills and trusts while they engage in several different areas of the law. Most of the attorneys may have attended a few seminars on living trust, probably used trust forms from a book, and will likely use the statutory forms of power of attorney and advanced healthcare directive. As I've already indicated earlier, these are inadequate. The general practice attorney often has a short interview process and usually uses an assembly line approach for the preparation of living trusts, selling living trusts like they were tires or a box of cereal. Because of a lack of expertise, important issues are often missed by the general practitioner, which may have the same disastrous consequences as a self-help planning option that I described before. Also, the general practitioner frequently cannot explain many of the provisions in the living trusts that he or she prepares for clients. I believe that the best planning option is to use a board-certified specialist in estate planning, trust, and probate law. The board-certified specialist has years of experience, has passed a highly competitive examination, has been recommended by other attorneys, and is constantly engaged in advanced study and ongoing continuing education. The specialist is often aware of legal issues for a family and their estate planning that are not known by general practitioners and are often completely ignored by self-help solutions. The specialist can ask the hard questions that need to be answered and can also answer your questions about your concerns, your wishes, and your desires for estate planning for your family. The specialist can also create a custom-designed estate plan for you and your family, incorporating all of those wishes, concerns, and desires. Best of all, a certified specialist in estate planning, trust, and probate law can create a customized plan for many family situations, such as a second marriage, a marriage where one or both spouses have substantial separate property assets, where there are children from a prior marriage or relationship, where there are special needs beneficiaries, where there's a non-citizen spouse, or beneficiary, or proposed trustee for a trust, all of which have potential tax implications or other problems. Besides living trust planning, board-certified specialists can create other trusts for estate planning purposes as well. For example, a trust can be created that protects an inherited retirement plan from being lost in a similar fashion to Castle Trust Planning. This is called the IRA Retirement Trust. Wealth preservation trusts, or irrevocable life insurance trusts, can provide for an income and estate tax-free inheritance for a spouse, partner, children, or other heirs, or it can be used to bring cash into an estate to pay taxes and bills so that real estate or other assets don't have to be sold. Supplemental needs trusts can be prepared to protect the inheritance of a special needs spouse, partner, children, or other heir from being lost to the government, by assuring that the inheritance does not need to be used up in order to qualify for assistance from the government. Many of those who attend my seminars, either online or in person, already have a living trust estate plan that they prepared or had prepared several years ago. Major changes in tax laws and other considerations often mean that the estate plan prepared years ago is now inadequate, or may be much more than what is needed by a family today. New drafting approaches and innovative estate solutions are also now available that were either not offered in the past or were seldom used. A consultation to have your existing plan reviewed is highly recommended. This concludes my Living Trust seminar. I hope you found it both informative and entertaining. If you have any questions, please feel free to contact me at 408-247-0444 or by email at rpb@lawbob.com. You may also book a consultation and download consultation paperwork by visiting my website at www.lawbob.com. If you are watching this presentation by webinar, you may also use the button on your screen to book a consultation now. Thank you for listening, and I hope I can be of assistance to you in the future. Goodbye.